moves up.
Yeah.
So what you're looking at is section 1090 and section 1091 of the government code. I've underlined a couple provisions. Section 1090 is the provision in the government code that says a member of a legislative body cannot have a financial interest in a contract. And that makes sense. I underlined a couple words that may, upon first reading, not be as broad as you might think. So the first phrase, financially interested. What Director Corolla said is he's not receiving commission, he's a salaried employee, he really had no direct financial gain by selling the windows. Well, you look into the cases, and it's actually an extremely broad interpretation of what it means to be financially interested. So it's not just direct benefits, it's indirect benefits too. And so the theory is that by awarding a contract, even when this particular person is an employee, that somehow creates greater job security and it allows the company to stay in business and the employee to remain employed. So that's the theory. So it's a very broad interpretation. The same can be said as a phrase made by them. The contract technically was not made by the board. It was made under the procurement policy, which is a policy that was adopted by the board for purchases involving less than $5,000. Right? So the district has, I don't know, 100 of these every month. Very small purchases from a matter of mere dollars up to a couple $1,000s. And this particular purchase of glass fell within that exception. Well, so the fact that the contract was not technically made by the board, again, this is a very broad interpretation. And what the courts have said is if the contract is made by any delegated authority, and in this case it could be argued that the procurement policy was a delegated authority. So the fact that Mr. Ladrini, a district employee, operating under the procurement policy, entered into the arrangement with Miller Glass, it could still be argued that this falls within 1090. Okay? So this is the rule. 1090 is the rule. If you flip the page, 1091 is the exceptions to the rule. And the legislature recognized that there will be times when there is a remote interest, that it's not millions of dollars we're talking about, it's a pretty attenuated interest in an agreement. And so again, I've highlighted some words, some provisions here to help you understand it. And in subdivision A, there's basically two parts to subdivision A. The first part is notice. When there's an agreement entered into that arguably falls in section 1090, the rule, then you need to comply with subsection A here. And that first part of that is provide notice. And this notice, I think, could be anything from Director Corolla stating for the record that he's an employee of Miller Glass and that Miller Glass intends in the future to possibly provide material to the district. And so the notice could be as informal as that, or it could be something much more formal, like a written policy of the district that recognizes the employment of Director Corolla. The second part of subdivision A is that when you have a potentially interested contract, the board needs to approve it. And it needs to be authorized, approved, or ratified. And so that to me says the board could approve it beforehand, at a board meeting, or it could ratify after the fact. So flip the page, and we go to sub B and sub B2 and sub B3. And this is where we get into really the nitty-gritty of whether there's an exception that applies. And so let's go to 2, for example. 2 has 5 parts. The contracting party, in this case Miller Glass, has 10 or more other employees, and it does. 2, the officer was an employee or agent of that contracting party for at least 3 years prior to taking office, and Director Corolla was an employee for more than 3 years. 3, the officer owns less than 3% of the shares of stock of the company, and Director Corolla owns no stock in Miller Glass. 4, the employee or agent is not an officer or director of the contracting party. And again, that's correct. Director Corolla is not an officer or director of Miller Glass. And the last part is the director did not directly participate in formulating the bid. Now, what does it mean to directly participate? And if we ask everybody in the room, probably everybody's going to have a slightly different answer. And this is where confusion is. This is where lawyers make a bunch of money. Nobody really knows. There's what the Director Corolla said is he was aware of the bid, he made a couple suggestions, then handed it off to somebody else at Miller Glass. It's possible that that is enough to directly participate in formulating the bid. It's possible, which would mean that this exception wouldn't apply. And the exception in 3 is very similar. You see that it has the directly participate language. It also has a clause in there that's primary management capacity. Again, legal phrasing, nobody knows what it means, but if Sepp is a manager of Miller Glass, it may kick him out from him being eligible under this exception. So I can't say definitively whether there was a violation or not. What I can say is there's enough here that we should fix it in the future and make sure that there's no question, that there's no violations. So what I think we need to do, what I recommend to the board, is that Director Corolla have a written statement, and we can put it on the agenda for another meeting, that outlines his position at Miller Glass. It'll state that he will not have any role in formulating bids in the future. And then, notwithstanding what the district's current procurement policy says, we need to have those contracts that Miller Glass is awarded come to the board. And Director Corolla would have to abstain from voting on that, and it would be up to the other directors to decide whether they wanted to award the contract to Miller Glass. So that will be my recommendation. I can obviously assist the staff in putting it on paper, and the board will be able to consider it at a later meeting.
Are you saying that if we considered it at a later meeting, that would be in effect the board ratifying what has already occurred, and then it would be a legal contract?
No, I think this is for contracts moving forward.
One question, we had an ethics program which was given by your office, and in that meeting, Mr. Corolla asked if there was any problem with that, with his company bidding on it. And we were all told that there was no problem.
There isn't in theory, provided we follow these procedures. So,
But isn't that sort of a notification to the board that Miller Glass?
absolutely. I mean, Director Corolla wears his Miller Glass colors proudly. I think we've all known that he's an employee. It's just, we need to make sure in the future that there's no question that this is legitimate. The district is getting a bid that is legitimate, and there's not any unfair advantage, those types of things.
And what was the aspect of the procurement policy that required Miller Glass, that particular section go out to bid? Was it the amount being more than 1,000, or what's the?
More than 1,000.
Oh, it is more than 1,000?
Must be a formal.
Oh, and if I follow what Dustin's saying is correctly, what the policy going forward would be, and it would be generic, not just for SEC. because it would carry forward into the future. So we would go in a generic form, if a director is an employee of the company that may contract with the district, they need to make a statement, saying they're not going to be involved and they won't personally benefit, and that all future contracts that they bid on will have to come to the board for approval regardless of size, just to keep it clean and transparent.
And contracting with the district, is that really a formal contract, or is it the fact that we stopped into Miller Glass and picked up a 2x2 sheet of glass and paid them $20 and came over here?
That's an agreement. An agreement does not have to be a written form. So I think this was probably a
So that would
purchase
be-
order.
That would be contracting with the district?
Yeah, that,
So I just want to bring up something that I think is kind of a ludicrous example, taking this to the far ends. Have we not in the past gone down to Safeway and purchased a bunch of sandwiches to feed the board meeting or public or an employee function of what was going on?
Yes.
In fact, that was a contract between Safeway and the district. So what you're saying is that if Larry happened to be a stockroom clerk working for Safeway, that we could not just go down to Safeway and buy those sandwiches. We would have to have a board approval to purchase $110 worth of sandwiches, to bring it in here and feed this group, or go to Albertsons or someplace else.
yeah, what we would do is we'd walk through this and we'd start with 1090. What's the rule? Okay, he's an employee, he's got an interest in continued employment. Then we'd go through to the exceptions. And provided there was notice and the things in sub A, the difference in your hypothetical, you said he's a store clerk. So I don't think he's making the sandwiches. Well, he didn't directly participate.
He's not the bread.
Yeah.
He brings the bread to the deli.
But your point is a fair one. I mean, that's why you see this kind of stuff in the news all the time. Districts violating the Brown Act, for example. A lot of times there's not intent to do that. Occasionally there is, but most of the time, it's an innocent mistake. It's not done with any malicious intent. Just because there's a lot of laws out there that are complex, and it happens. So the key is, in this case, or the Brown Act, anytime there's what I consider a technical violation, or possibly a technical violation of the law, acknowledge it, and then in the future fix it so that there's no questions.
Question. Several of my clients deal with the district. Is there a problem with me because my client is dealing?
No, that's enough separation for
Well, make sure. Okay, is any of the directors have any more questions of the staff?
I'd like to make some comments.
Yeah, we'll make comments afterwards.
Oh, okay.
Right. Any more questions of the staff from the directors?
Well, I have a big question. What are we doing here? What are we going to accomplish tonight?
Well, are you directing this at me?
Yes.
Because I don't know that I'm the right one to ask that.
I mean, we're here, and when we got a big legal concern, from my rough estimate, we're spending about $5,000 of the district's money, and that means we're spending $5,000 of ratepayer money taking a look at investigating this $1,500 limit contract. I don't like spending money like that.
Yeah, that's fair.
Okay, so what are we going to accomplish tonight? Are we going to ratify this contract, fix it in the future and move forward? Or are we going to persecute this to the full extent of the law here and put Seth in jail? Or
The reason
what are we gonna do?
The reason we're here is because of this getting started.